get started.
The recording's been started.
Great, thank you.
You recorded. Got it. Okay.
Great.
All right,
We know
well,
it's being
now,
recorded. Okay.
That's good to know.
so I'm gonna ask everybody to mute yourselves just for a moment while I kind of give an introduction, and then we can you can unmute yourself when it's time to speak. So it's 2:04 p.m. We're on the Zoom meeting that was identified in the notice of appointment of hearing officer and hearing. We're at the scheduled time and place for the IDL hearing number CC-2021-PUB-10-001. This hearing is related to encroachment permit application ERL 97S0477C filed by Desiree Burke seeking authorization to place a mooring buoy on Priest Lake. Ray and Carolyn Hunter, adjacent Littoral owners, have objected to the application. The Idaho Department of Lands is the agency authorized to issue encroachment permits under Idaho law. My name is Andrew Smith. The director of the Idaho Department of Lands appointed me to be the hearing officer on this matter. To provide a brief overview of the hearing, I want to take a quick roll call. I'll swear in those people wishing to provide testimony today. I'll review the record, and then we'll go into taking testimony. So with that, we'll start with the Burkes. I see a Bill Burke on there. We'll go ahead and have you guys identify. You just state your name for the record, please.
Bill Burke. And also my wife is here too.
Desiree Burke.
See that for our conference.
Okay, and then so the applicant on this application says Desiree. Ms. Burke, will you be representing yourself, or will you have your husband or your son represent you in this matter? And basically what I mean by that is each party will have one person, it's either themselves or another person designated to excuse me, if they want to raise an objection, or it comes time to ask people that are providing testimony, asking questions. It's that person who's designated to kind of speak on your behalf. So, so Miss Desiree Burke, will you be representing yourself, or will you have either
My son, Christopher Burke.
Okay. All right, Chris, will you go ahead and identify yourself for the record?
Yes, sir. This is Christopher Burke, and I'll be representing Desiree Burke as agent for her.
Awesome. And then, Mr. Burke, do you plan on providing testimony today?
It depends on where the dialogue goes. I've, prepped all the attachments, all the exhibits for depending on where the dialogue goes.
Okay. How about your mother or your father? Do they plan on providing any testimony today?
I'll let them speak for themselves, but I don't believe so.
No, unless we're asked specific questions of some kind. No, Christopher speaks for us.
Okay. All right, great, thank you. We'll go to Ray and Carolyn Hunter.
You're gonna have to be a little louder for us. Hard time making out what you're saying.
All right,
Okay,
I'm sorry. I'll speak in the microphone as best as I can.
all right.
So Mr. Hunter, will you identify yourself and your wife and any witnesses you will call?
You want me to identify myself?
Yourself and
Yeah. Myself and my wife, I'm Ray and Carolyn Hunter. My daughter is Catherine Kuhn.
Other daughter, Susie Stanford.
And our daughter is Susan Stenberg.
Mr. Hunter, do you plan on providing testimony today?
Yes,
That's your wife?
no,
How about your daughters?
yes.
Thank you. Ms. Kaufman?
Good afternoon. So I am here as the Deputy Attorney General representing the Department of Lands. As I mentioned before the recording started, Mr. Amer will be presenting the testimony, the hearing statement on behalf of the Department of Lands and answering any questions. I don't anticipate offering testimony, perhaps a legal clarification if one is needed. I may ask some questions, although that's pretty rare in these types of hearings. But I don't intend to offer any testimony.
Thank you, Ms. Kaufman. Going around to the other participants. Let's go with, I see Ryan. Would you mind identifying yourself, please? I can't hear. Can anybody else hear Ryan?
No, I can't.
Can you hear me now?
There
Yes.
you are.
My name is Ryan Zanhusen and I work at the Priest Lake office for the Idaho Department of Lands.
Awesome. Thank you for joining us today, Ryan.
Yep.
See, let's go to Dan Brown. We'll maybe come back. How about Amity?
My name is Amity Houston and I work for Idaho Department of Lands at the MICA office.
Thank you.
Mr. Smith, I can just jump in for Mr. Brown and as counsel for the agency, introduce him. Dan Brown is the area manager for the Priest Lake area office for the Idaho Department of Lands. As I indicated, I don't anticipate that he'll be providing any testimony today. That'll be handled by Mr. Amer. I assume that Dan is listening in simply because the application in question is with the area that he manages.
Thank you. And Chris Gosa.
My name is Chris Goza. I'm with the Idaho Department of Lands, and I'm here to facilitate the Zoom meeting for the hearing.
I really appreciate your help today, Chris. Thank you. And then Joy and JJ.
Hello, my name is Joy Vega, Deputy Attorney General. With me is JJ Winters, also with the Attorney General's office, and we're assisting Mr. Smith as advisory counsel for this matter.
Thank you. And I see Lauren and Eric.
Yeah, my name is Lauren Moore. I'm working with the Idaho Department of Lands, and I'm here today as an observer.
Eric Wilson, Bureau Chief, Resource Protection Assistance with Department of Lands, also just observing today.
Thank you. Is there anybody I missed? Okay, great. Well, thank you all for joining today. Want to use our time as efficiently as possible. So with that in mind, what I'm going to go ahead and do is each person who's identified that they're going to provide testimony today, I'm just going to ask that we go ahead and swear you in. And so what we'll do is I'll start with Chris Burke. So Chris Burke, do you swear or affirm that the testimony you give today is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you very much. Ray Hunter, do you swear or affirm that the testimony you give today is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Catherine Kuhn, do you swear or affirm that the testimony you give today is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Susie Stenberg, do you swear or affirm that the testimony you give today is the truth, the whole truth, and nothing but the truth? You're muted. Can you unmute yourself? And
Yes.
thank you very much. I appreciate that. And then Mike Gamer, do you swear or affirm that the testimony you give today is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Great. Thank you all very much. All right, moving on to review the record. So my decision is going to be based on the information provided in the record. The record consists of testimonies provided and the exhibits admitted to the record during the hearing today, as well as the agency record. So the agency record so far consists of Ms. Burke's October 15th application, The October 19th notice of application to the Hunters and Brian Creel. Mr. and Mrs. Hunter's November 8th objection to the application. The November 10th updated drawing submitted by Mr. Burke. November 12th notice of application to the Hunters. The December 9th email waiving the 60-day hearing requirements. And the December 16th notice of appointment of hearing officer and hearing. Prior to the hearing, the parties exchanged exhibits. Again, to kind of help facilitate the hearing today, I'll go ahead and ask Mr. Burke, would you like to go ahead and offer up all of the exhibits into the record at this time?
Yes, sir.
Okay, as we do that, one question I had is, it looks like there's exhibits A through Z and then AA through JJ. When I was looking through these, I did not see an exhibit I, O, S, or II.
Oh, that's best practices. O's can be confused with zeros, I's can be confused with ones, S's can be confused with fives. So that's why you admit them when you're doing numbering sequence.
Perfect. Okay, so at this point, would you like to offer up exhibits A through JJ minus those four?
Yes, sir.
Okay, thank you. Mr. Hunter, do you have any objection to that? Admitting those exhibits into the record?
Can you explain it?
Yeah, so basically,
The exhibits that you saw, Dad, do you have
Okay.
objections?
Are you talking about the exhibits?
That Christopher put into the record?
Yeah.
Do you have objections? We have two comments about two of the exhibits that we were going to enter in when we were doing our testimony. Other
okay,
than that, we don't have
Yeah.
objections. We
Yeah.
just have two comments about two of the exhibits that are part of our proposed testimony.
okay, perfect. And yeah, well, please make a note of that. And when we get to that point, you have the opportunity to provide those comments.
Okay,
For now, I just wanted to establish
Right.
So did I hear you say there you do not object to admitting any of those exhibits into the record provided by Mr. Burke?
we don't object.
No, that's fine.
No objection.
No objection.
Thank you. Ms. Kaufman, do you have any objections to any of Mr. Burke's exhibits?
No objection. Thank you.
All right, thank you. With that, then applicants of the exhibits A through JJ are admitted to the record. Mr. Hunter, it looks like you had exhibits A through C that you offered. Would you like to go ahead and offer those into admission at this point?
So yes, you offer exhibits A through C. You
Okay.
just affirm that you're offering, yeah.
Yeah, I'm offering those. Yeah, that's fine.
All right, thank you. Mr. Burke, do you have any objections to those three exhibits?
Potential comment depending on where the dialogue goes, but no objections to admitting them.
Okay, thank you. Ms. Kaufman, any objections to the objectors exhibits A through C?
No objection. Thank you.
All right, thank you. So Mr. Hunter's exhibits A through C are now admitted. Ms. Kaufman, did you, besides the hearing statement, does IDL have any exhibits they wish to offer?
No, the hearing statement would be the only exhibit to the extent is an exhibit. We would certainly offer it as part of the record, but as the hearing officer may know, it's standard that Mr. Amer will summarize the testimony that's set forth in the hearing statement verbally, but we do provide it to the parties ahead of time and provide a written copy for the record. So to the extent that I would need to offer it in order to make it a part of the written record, I'll do that now.
Okay. Mr. Burke, any objections?
No.
Mr. Hunter, any objections?
No, as long as we get copies of the testimony and the transcription.
Okay.
You do have copies of those. That was what they.
Yeah, no objection.
Okay, sounds great. Well, thank you all. So we'll proceed with the hearing as follows. The applicant bears the burden of proof in this proceeding. So we'll start with giving Mr. Burke the floor, where he can present the application, evidence that supports the application, following which Mr. Hunter will have the opportunity to ask Mr. Burke any questions. Ms. Kaufman will ask any questions, and then we'll proceed to that point. So with that, Mr. Burke, the floor is yours.
I thought we were going to start off with Mike's statement of the, IDL's position finding. I'm happy to roll if you want me to, but I thought we started off with IDL's entry.
I typically, we'll let the applicant go first just because they carry the burden of proof. But if you want to,
Okay, that's fine.
Check with Ms. Kaufman.
No, I'll go ahead. So would you like to bring it up on your end, or would you like me to bring it up on my end?
Let's do this. If you have a document you'd like to pull up, let's have go ahead and ask Chris Goso. He's
Okay.
kind of our.
Let's just start with Exhibit A. I mean, that's the R1 encroachment drawing, and we'll just talk from that.
Okay, bear with me for one moment. Let me go ahead and get that pulled up.
Yeah, you're good.
And Mr. Hearing Officer, would that be document number 008?
That is correct, yes.
Okay, one moment. Let me get that shared.
So they're going to share the screen and I'm going to show Chris's exhibit.
Okay.
And sorry, real quick, Ms. Kuhn, do you mind muting your microphone while Mr. Burke provides the testimony, please?
Absolutely. Okay, and are you able to see that document being shared now?
I can see the list of exhibits, but I can't see the actual exhibit yet. You might
Okay.
have like two screens going.
And which exhibit were we looking for?
Exhibit A, titled Mooring Buoy Encroachment Drawing R1. There you go. You're right. You're starting to get into it.
Okay, I'm going to try to make it.
Okay,
fit the
so this
screen
is
here.
this is the revised, the second drawing that was submitted for the encroachment application. And what this shows, the way this is generated was it's a composite of Bonner County GIS images and on the ground measurements and photographs. And what I've done, the reason I have so many attachments behind this is I've included the GIS, underlays used to build this, the photographs where you step through how you determine, the position of the marker, the angle of the property line, how it runs out to the shore, the high water line of the shore, the low water line of the shore, the USGS gauge measurements for Priest Lake showing that the photographs were taken at high and low water. So this document here is a composite of GIS, physical measurements on the ground, and photography of high and low water at Priest Lake. And, we've done an accurate representation here of the runouts of our respective property lines to the high water mark, the angles from our shared property lines to both the Huckleberry Haven North property line, as well as our other adjacent neighbors, the Frills shared property line, and the methodology here of how we bisected the angle between those lines to come up with the littoral line, and then maintained the 30-foot setback off of that littoral line per the Idaho state code. So at this point, I'm happy to walk you guys through all the backing up documents. I have a feeling that maybe some of the hunters' questions will take us down that road. But all the backing up documents are basically the supporting set of how this drawing was generated. We're maintaining the 30-foot setback per the rules. We're not going beyond the line of navigability per the rules. We're just operating within our littoral rights to establish a mooring location.
Well, thank you, Mr. Burke. Do you have anything else to add now, or do you want go ahead and open up for questions?
I think at this point, open up for questions. And like I said, the backing documentation of how this was generated, it's all been submitted as exhibits.
Okay. Mr. Hunter, go ahead and turn over to you if you have any questions for Mr. Burke.
You're on mute. Kathy's on mute. I don't think you saw that.
Yeah, I have no questions on what he's presented so far.
Okay. Ms. Kaufman, do you have any questions?
No, there are no questions from the Department of Lands.
Okay. Mr. Burke, is anybody else speaking on behalf of the applicant today?
No.
Okay. Well, with that, thank you very much. I appreciate the comments today, Mr. Burke. And with that, we'll go ahead and turn over to Mr. Hunter. Mr. Hunter, the time is now yours to provide your comments, your testimony, review the exhibits that you have been admitted to the record, and make your case.
Yeah. Do we have that in Exhibit A?
We would like Exhibit A
Can you
pulled
put
up on the
Exhibit A up
screen.
there?
Yes, while he's talking.
Okay, give me one moment. I'll go ahead and get that pulled up. And Mr. Hearing Officer, will that be document number 11?
That is correct, yes.
Okay, one moment.
And you might explain the old doc and the new doc on the picture first, because it might be confusing. Solid lines.
Yeah. Okay.
Before you start.
That's it.
Okay.
There's a little confusion, well, not confusion, but the solid line on the dock is the dock has been, and the dotted line is the proposed dock. Can you see that? Is that visible?
It's the shape of an F, the dotted.
Correct.
Okay.
It's the proposed.
Okay. All right. Well, just to begin with, we've seen all that they've presented on this thing, and it does certainly give us a problem. We just have a 50-foot lot, and therefore use, of course, all the water that's in front of our actual property line. In looking this over, we want to everyone here to be on notice that this we consider to be a dangerous hazard. And as such, want to make that into the record that we consider it a dangerous hazard, and the proposition that's there. Because from the proposed buoy, just to speculate, a 20-foot boat and a 10-foot line from the buoy to the boat will leave a very small egress and access between the boat and the expanded dock to the north. With wind and wave action, the access and egress to and from our lot will be very narrow and constitute a severe and dangerous hazard, and everyone should be on notice about that. At night, there won't be any lights on the moored boat, and we consider that to be a hazard in navigating back and forth through the beach, and we do run watercraft off the beach. So we will be forced then to go south toward the Burke dock and around the buoy and near their dock just to get back and forth. And that also, with that out there, we consider that to be a hazard to swimmers. As I mentioned, the wind and wave action between that boat that they've got on the buoy moored to it and the back end of it heading north as the waves and the wind do go, will leave such small room that we will not probably be able to navigate between that boat and the expanded dock. And that would force us then to, as I said, to go around the buoy on the south end in front of their dock just to get to our beach. So we consider that not safe also. Also, there are large boulders in the water near the Burke dock, and the water is shallow there. It's a definite hazard for boats trying to navigate through there. And also the buoy then will be in the way. Then with the Burke boat floating north, it will cross probably what you call the littoral line, depending on the length of the rope and the length of the boat. And of course, with the prevailing winds and water, the way they are, the boat will be most of the time probably on the north end of that buoy. And of course, we have no control over the length of the boat or the length of the mooring line. As to our boat near the dock, we park the boat with the bow out. The bow itself is out. We need to have sufficient space to swing a boat around to moor at the dock, bow out. It's possible to swing our boat out, even a minimum will hit a moored boat, because depending on the size of that boat. Now, as far as we're concerned, the state needs to be on notice that we view this as a potentially dangerous situation for swimmers and boaters, particularly for swimmers, due to the navigation that's needed if the moored boat is in the way. Now, I'd like to have my daughter comment on the rest of this a little bit on these subjective items. Go ahead, number 12.
I really did want to emphasize the swimmer issue. We understand that the Burkes might be concerned about swimmers, and maybe that's why they're putting in this mooring buoy. But the ultimate irony here is that putting in this buoy, because we have no control over how long the mooring line is or the boat, is a severe hazard potentially to the swimmers in the Hunter property, because swimmers are not aware of littoral lines. Swimmers are aware of property lines. So when you look at Exhibit A, you will see that the swimmers sit on that beach, which is only 50 feet, and swim straight out. So clearly they swim, and we've done this for the 50 years that we've been on this property, and they swim right in that area. So we view that as a severe hazard to swimmers by any boat navigating through in that area. So more to that point, the Burkes have 75 front feet. The Hunters have 50 front feet. In our opinion, there's plenty of room on the Burke property to move the mooring buoy south of the present proposed location and still be operational by the Burkes. You'll see on this drawing that the mooring buoy, as where it's proposed right now, is 41 feet north of the Burke stop. We question why it needs to be 41 feet from their dock. And even if that's operational, how do you operate a boat? How do you reach the boat? How do you effectively use it as a practical matter when it's 41 feet from your dock? So at a minimum, our position is that there should be a compromise to move the buoy south as much as possible. And wouldn't that in fact be more usable by the Burkes to have it closer to their dock for ease of accessing their moored boat? Again, our biggest concern is hazardous swimmers, whether it be any swimmers on the Burks or the Hunters Beach. And we believe a compromise in moving the buoy south mitigates what we consider to be an incredibly dangerous situation. Further, we ask, why do the Burks want to do this? They have a dock now for 2 boats and a lift. They've owned these boats for many, many years. We do question the need for a mooring buoy now, other than to obstruct the Hunter dock. When you look at that drawing again, as we show, we have the dotted line representing our new proposed permitted dock overlaid by our old dock, which is no longer there. And so we look, when you really look at that drawing, you'll see that it's not even that much of a change from the dock that we've had for many years. So again, we just have to sit back and question the need or the use or the purpose for this particular permit, other than to obstruct our need for this dock. And then finally, our bottom line is truly, we're trying to be reasonable here. We understand what the regulations say. We've read them thoroughly. We understand the Attorney General's position. We're not arguing with the regulations. What we're asking for is reason here. And it has to do with the danger that I don't think comes through when you just read the regs. And so we are trying to be reasonable. We're asking for compromise. If they need a mooring buoy, they need a mooring buoy, but we ask if it could be moved 10, 20 feet south of where it is right now. Again, just so people understand the picture we're looking at here, our family owns 2 parcels. And so we have the option of actually building 2 docks. And we choose not to do that. We're permitting for that shared family dock that you see there in that dotted line F drawing. And that we're doing that because we don't believe it's being neighborly to build 2 docks on the Huckleberry Haven and the Hunter parcel. But we actually are within our rights to do that. And if we actually had to do that, then if we have 2 docks, we would end up building a second dock that literally would be placed 11 feet off that littoral line, which is a worse situation than the situation we're asking for and being permitted now. So again, we're actually trying to use common sense, be reasonable, avoid a hazardous situation, and we're up for compromise. So our compromise is, could it be moved 10, 20 feet south of where it is now? You know, again, we know this is within, strictly speaking, the littoral line. We believe it was placed exactly on that 30 feet setback so that it could exactly obstruct us. That's no coincidence that it's being placed on the 30-foot setback, and we understand that. So we're asking for reason and compromise. And again, we are putting the state on notice of a clear and present hazardous situation if this is permitted as is. Thank you.
Essentially, that's what we have to say.
You have something else?
No. Okay. Mr. Hearing Officer, I believe you're on mute.
Thank you. Mr. Hunter, can you repeat the last thing you said? Mr. Hunter?
Yes.
Will you repeat the last thing you said, please?
Could you repeat that?
I had asked you to repeat the last thing you said.
Repeat the, I'm sorry, we still can't hear
We
you.
can't hear you.
Repeat the last what?
I just need Mr. Hunter to repeat the last thing he said. I didn't understand it.
Oh, you said this is the end of our testimony.
Oh, I just said that was the end of our testimony.
Thank you. Mr. Burke, do you have any questions for either Mr. Hunter or Ms. Kuhn?
No questions. You know, I can provide a response on a couple of facets that they brought up, though.
You didn't go over the exhibits, you do have a comment.
Okay, you're welcome to, Mr. Burke, if you'd like.
Yeah, so two things. First thing, the concern around a mooring buoy and safety seems highly paradoxical to me. The hunters have used 2 mooring buoys on their lot, and I can show an exhibit CC and DD of those in use in recent years.
Anchors.
So I'm sorry, was there a question on the phone? Can folks hear me okay?
I can hear you, please.
Okay. So why the argument of safety with the mooring buoys being brought up right now when the hunters have had mooring buoys in use in their lot? That, to my best knowledge, unpermitted for many years. Seems highly paradoxical and kind of just tailored to not liking what we've proposed here in this application. The second thing I'd like to bring up is around primary intended use case for this buoy. So in summer of 2019, we acquired a second boat. It's a 14.5-foot Lund. We also have an 18-foot Sea Ray. We utilize our boat lift for the 18-foot Sea Ray. And when we come up to the lake, we bring the 14-foot Lund with us. In the summer of 2019, I was up there with the family, and we didn't have the Sea Ray with us. We just had the little Lund, and I put it in our lift, and we had a northern storm. And in the middle of the storm, I ran out there and basically had to tie the corners of the boat down to the boat lift. Otherwise, we would have lost the boat. Last summer, we had both the Sea Ray and the Lund at the lake at the same time while we were up there. Same kind of situation, northern storm. I ended up having to run the boat over to an adjacent, a family friend of ours lot, and hide it behind a boathouse just to weather the storm. And even that next day, the thing had taken a beating and was swamped. So the intended use case for this mooring buoy is we have 2 watercraft. We've got 1 boat lift. The boat lift is sized and appropriate for the Sea Ray. It's not appropriate for the Lund. So this buoy enables us to have a second mooring location. Again, primary intended use case is around northern storms. You can't put the boat on the south side of the dock, or the northern storm basically destroys the boat against the dock. You know, we may end up using it for if I have to do maintenance on the boat lift. You know, it may be used for overflow, but really in normal everyday use, the boats are either the Sea Ray is going to be in the lift, and the little Lund, the 14.5-footer, will be on the side of the dock. This buoy gives us an option to moor the boat safely without damage to the boat in the event of northern storms, but also southern storms.
All right, thank
So
you.
that's why it's located where it is. You know, it's equal distance between the docks that are existing at the time of permit, and it's within all boundaries, setbacks, and, you know, littoral rights for our respective piece of property.
Thank you, Mr. Burke, for that. Do you have any questions for Mr. Hunter?
No questions.
Thank you. Ms. Kaufman, do you have any questions for Mr. Hunter or Ms. Kuhn?
I do just have, I have a point of clarification and then a couple of questions for whoever in Mr. Hunter's group wants to answer. So my point of clarification is that there was a reference made to the Attorney General's opinion. And I think that was a reference to the Idaho Department of Lands hearing statement. And I just want the record to clearly reflect that although I submitted that hearing statement on behalf of the Idaho Department of Lands, it is the Department of Lands hearing statement. It is not the Attorney General's statement, and it is not an opinion of the Attorney General. So I would just like the record to be very clear in that regard. So in terms of the questions, and again, whoever from the Hunter group would like to answer these questions, it's fine with me. I'm not particular about that. There was some discussion at the outset about the proposed dock, and I see that we still have Hunter's Exhibit A up, and so the proposed dock is shown in an outline form in the dashed line. Could someone tell me whether an application for permit has been submitted to the Department of Lands for that dock? I think probably go ahead, whoever could answer that, although Andrew, I don't know if maybe they're looking for an okay from you to answer that question.
I don't know. Yeah, go ahead. I don't know if we were muted. Do I need to repeat what I just said or?
Yes, please. I believe you were muted. I couldn't hear what
Yes,
you
so
said.
yes, I'm sorry, we were muted. So yes, it has been submitted to IDL within probably the last 2 weeks.
Or it was supposed to be.
By our dock builder, Kevin Hansen.
Okay.
And so that's why I'm not sure of the exact date, because Kevin has been the one handling the permit submission process for us.
Okay. So if the application was submitted in the last couple of weeks, then would I be correct in guessing that the application is still being processed to the best of your
That would
knowledge?
be our assumption.
Okay. So also, again, to the best of your knowledge, has a permit been issued for this change dock?
No, a permit we have not received any communication that a permit has been issued.
Okay.
That's
Okay.
neat.
All right. I think that those are the only questions I had, Mr. Smith. Thank you.
Mr. Smith, you're on mute, sir. Fun with mute buttons.
Sorry about that. Mr. Hunter, Ms. Kuhn, thank you for your presentation today. Ms. Kaufman, I'll turn the time over to you for the Department of Lands presentation.
Thank you very much. At this time, I'll just turn the time over to Mr. Amer to present the statement for the Idaho Department of Lands, as is also our practice at as is usual at these hearings. I think he may skip over some of the legal provisions that are set forth in writing in that statement because they can be quite lengthy, but I'll leave that to his discretion and just turn the time over to him.
Thank you, Ms. Kaufman. Yes, correct. We've passed out the hearing statement before the hearing, so everyone's had a chance to look at it. As customary in these proceedings, I tend to skip over all of the legal provisions, the rules that we looked at when processing the application, and kind of just highlighting a couple sections. So I will start off with off the top. Good afternoon. My name is Mike Amer. I'm a Lands Resource Supervisor for the MICA Supervisory Area Office of the Idaho Department of Lands. And I'm the supervisor of the Navigable Waters program at IDL. My purpose in being here today is to provide you with information regarding IDL's assessment of application for encroachment permit ERL 97S477C filed by Desiree Burke. Burke is seeking an encroachment permit for a mooring buoy located on the eastern shore of Priest Lake, just south of East Twin Island. The proposed mooring buoy will be a Coast Guard approved buoy secured to the lake bed via a concrete anchor, galvanized chain, shackles, and D-rings. The proposed mooring buoy will be located 30 feet from the northern littoral line shared with the Hunter property. Burke has an existing permit, ERL 97S477B, for a 4x12 fixed ramp, 3.5x8 hinged ramp, and then an 8x24 floating dock, the concrete anchor, and domestic water intake line. And that permit was issued on July 5th, 2001. As far as the timeline goes for this application, on October 15th of 2021, IDL received an application for a mooring buoy. On October 19th, 2021, IDL sent adjacent neighbor notices to Brian Friel and A. Ray and Carolyn A. Hunter. On November 8th of 2021, Hunter mailed an objection letter to IDL. On November 10th of 2021, IDL emailed Burke asking for a revised drawing that better clarifies accurate measurements of water frontage. That same day, Burke emailed IDL a revised drawing that showed the proposed location of the mooring buoy and provided more explanation on water frontage. On November 12th, 2021, IDL re-notified the adjacent neighbors with the revised drawing. On December 3rd, 2021, IDL called Hunter to confirm that they received the revised drawing and determine if they still wanted to pursue a contested case hearing. Hunter confirmed they did receive the drawing and that they would still like to proceed with the hearing. December 9th, 2021, Burke emailed IDL and stated they would waive the 60-day deadline for a hearing if needed. And then finally, on December 16th, 2021, IDL's director issued a notice of appointment of hearing officer and hearing. I will skip section 2, which is the legal provisions. So these are the statutes and rules that IDL reviewed and looked at when processing this application. And I'll skip ahead to page 6, which is section 3. As far as littoral ownership goes, Burke owns one littoral parcel on Priest Lake, parcel ID number RP 00087000024A, with approximately 75 feet of water frontage. Burke is therefore a littoral owner with littoral rights. Should be noted that, as stated before, permit ERL 97S 477B was issued to Desiree Burke, and also a review of the Bonner County's parcel data, which is called Cloud GIS, shows that the owner of the property is Desiree Burke. So they are the owners. Type of encroachment, Burke is seeking an encroachment permit for a mooring buoy. The application type would be considered navigational encroachment. As stated above, Burke owns approximately 75 feet of water frontage, which is sufficient water frontage for navigational encroachment. Neither the LPA, which is Lake Protection Act, nor IDAPA have any square footage requirements for a mooring buoy. The proposed mooring buoy would be located outward into the lake 62 feet. The adjacent dock to the north extends approximately 75 feet. The adjacent dock to the south extends approximately 70 feet. Therefore, the proposed Burke mooring buoy would be located within the established line of navigability. IDAPA 20.03.04.015.09 provides in pertinent part that buoys must be installed a minimum of 30 feet away from littoral right lines of adjacent owners. The proposed Burke mooring buoy would be located 30 feet from the mutual line shared with the Hunter property. Littoral right lines in this particular part of Priest Lake are not simply extensions of the property lines. Rather, the littoral lines are perpendicular to the shoreline where the extension of the property line meets the ordinary high water mark. On the revised drawing submitted by Burke, it shows compass measurements to the property corners to the north and south. The littoral right line shared with the Hunter property bisects the angle created when measuring to the north and south. To help better illustrate this, the angle created when measuring the north and south property corners resembles a less than or greater than math symbol, and the littoral line evenly bisects the symbol. The methodology used by Burke is the same methodology used by IDL to determine littoral right lines. It should be noted that magnetic declination can change from site to site and day to day. The measurement listed on Burke's application may not be the same exact angles measured on the date of installation, should the application be approved. For example, on Burke's application, the bearing from the Burke-Hunter mutual property line to the north is 11 degrees. The measurement to the south is 211 degrees, and the Burke-Hunter littoral line bearing is 291 degrees. Those numbers may change a small amount due to magnetic declination, but all of the numbers would change uniformly, and the distance from the proposed buoy to Hunter's dock should not change. IDL recommends that Burke recalculate the angles on the date of installation to ensure the correct bearing for the littoral right line, as opposed to just assuming it will be 291. Especially since the minimum distance of 30 feet is being provided as a buffer to the littoral right line shared with the Hunter property. Additionally, IDL recommends that in addition to recalculating the littoral line, if approved, during installation, Burke needs to ensure that there is 52 feet from the proposed buoy to the Hunter dock as shown on the drawing. The conclusion, the drawings that were submitted by Burke all appear to meet the mooring buoy standards that are listed under IDAPA 20.03.04.015.09. Mainly being the proposed buoy is located 30 feet from the littoral right line, and only one buoy is being applied for with this application. Burke owns 75 feet of water frontage, which makes them eligible for an encroachment permit. Additionally, the proposed buoy does not extend beyond the line of navigability established by the adjacent permitted docks to the north and south. Based on the fact that the proposed is providing a 30-foot buffer and that the proposed buoy does not extend beyond the line of navigability, and that Burke is only applying for one mooring buoy, IDL recommends approval of the application. That concludes my statement, Mr. Hearing Officer.
Mr. Burke, do you have any questions for Mr. Amer?
No, I don't. I do have one clarification correction to my previous statements. Regarding when we acquired the 14.5-foot Lund boat, it was actually, we started using it in summer of 2020. And the two storm events that I referred to were in the summer of 2020 and 2021, not 2019 and 2020.
Thank you. Mr. Hunter, do you have any questions for
that's
Mr.
right.
Amer?
No, no questions for him.
Okay, thank you. Ms. Kaufman, any other anything else that the department would like to present today?
No, Mr. Smith, thank you.
All right, thank you. Well, let me do this. I would like to give everyone just one more, let's say maybe 2 minutes, just to give a closing remark if they feel so inclined. We'll start with Mr. Burke and Mr. Hunter, and then Ms. Kaufman again. So Mr. Burke, 2 minutes.
I have no further remarks.
Okay, thank you. Mr. Hunter?
Yeah, first of all, Burke mentioned something about buoys. We don't have any buoys. I think he's thinking about two of them, two jet ski anchors that we keep. They're just anchors. They're not a buoy. They're nothing permanent. They're just a jet ski anchor. So he was mistaken on that. What else now?
Yeah, well, just to elaborate on that a bit, we use them to anchor them like you would when we go up the shallows with our regular boat and anchor. And we see people anchoring jet skis and boats on Priest Lake all the time in the years we've been there. So they're temporary, they're moved out. They're there for a peak season, then they're moved out. They're not a mooring buoy.
They're not.
So we did want to clarify that we forgot to bring up two exhibits that we mentioned earlier, the Burke exhibits as part of our testimony. And so that was that exhibit number CC that showed the picture of the jet skis and claimed that they were mooring, that they're mooring buoys, but they're anchors.
They're just anchors.
So we wanted to clarify that. And then the other clarification was on Burke exhibit B, as in boy. Do you want to talk about it, or do you want me to?
Go ahead.
So exhibit B, I don't know if you want to pull that one up. Are we able to pull up the Burke exhibit B for a minute?
Yeah, Mr. Goza, I think that's going to be document 8.
Yeah, exhibit B, if possible, please.
Okay, let me get that pulled up. Give me one moment here.
A and C.
No, that's all right.
Let me know if that looks right.
No, it's an exhibit.
It's the one right above.
It has a T-shaped dock. There we go. That's it. Thank you. That's it. So this exhibit we were confused about because we're not permitting for a T-shaped dock. We're permitting for a frontward F, as shown on our exhibit A, the dotted line of frontward F dock. And it is true that at one point this fall, we did informally talk to IDL about a T-shape. Again, this whole thing is under the premise, we're trying to be good neighbors. We're trying to do the best thing for our neighbors on the north and the south. We don't want to permit 2 docks. We want to do 1 multifamily dock to be the least obtrusive possible to our neighbors. So this was something we considered. It wasn't even put into the record. It definitely was not sent out to the Burks or the Moffett neighbor to our north. And it was never even put into the record for IDL. It was a consideration, an informal conversation. So we were a little confused as to how the Burks even had access to this information, because the way we understand the process is we would submit, like we did, that forward F doc recently. And then, yes, we understand that that goes to our north neighbor and our south neighbor with their ability to comment on it. And so we have to question the entire IDL process, to be honest. When we see something put into the record by our neighbor who by all rights would have no way of even knowing that was happening. So we question how Mr. Burke is receiving his information from IDL. And that was just a point of clarification where we were very confused when we saw that particular exhibit because it wasn't part of the regular process. And that caused us, to be honest, to question flow of information and equitable process, I guess, for lack of a better word. So again, to conclude, we thank everyone for this process. And we understand the regulations. We understand the position paper from IDL. We are applying to appealing, I guess I should say, to reason, compromise, and the consideration
of danger.
Of the danger imposed by where it's going to be placed.
That's our main concern.
And none of that can be in the regs, and none of that could be, it's not going to be apparent from anything that's in the regs. And a lot of it's caused by the fact we have a 50-foot property. My dad, Mr. Hunter, does. And the Burks have a 75-foot property. And so these regs, they're tough to apply, I think, to this particular situation. And because there's 41 feet between the Burke dock and the mooring buoy, we believe it actually could be moved further south and still, you know, if they need a mooring buoy for the northerner storms or whatnot, we understand that. But we're asking why it couldn't be moved further south to avoid the navigation danger and the danger to swimmers.
And we do want in the record that that everyone is on notice, our consideration and looking at it, that it is going to be a dangerous potential or just a dangerous hazard situation. We want that on the record for sure, because we think it's important. And of course, we'll want the transcript too. Thank you.
Thank you, Mr. Hunter. Ms. Boone. Does IDL have any closing remarks they'd like to make?
Yes, I'd like to address a couple of things that were just brought up. As far as the jet ski anchors that show up, anchors or buoys, anything placed below the ordinary high water mark would be required to go through the application process. So if the hunters are in the process of applying and they would like to have such anchors for jet skis or a jet ski port, now would be the time to make such an application. And as far as questioning, I don't know if integrity is the right word, but as far as questioning the process, the hunters submitted an application. It's date stamped November 30th of 2021. And once we receive an application, it becomes public record. All of our documents are public record, with the exception of attorney-client information that we may email. So when the application was submitted on November 30th, it was date stamped by the Priest Lake office. It was date stamped, and that was where that drawing came from. Mr. Burke asked if you guys had submitted an application. I explained that you had, but it hasn't been fully processed yet. He asked for a copy of it through our public records request process. And through the public records request process, we are required to fulfill any records that are being asked of us that are public record. And again, once you've submitted an application to us, at that point, it becomes part of the public record. It wasn't part of the record for this hearing. There was nothing nefarious about trying to send it to Mr. Burke. He simply asked for a record that we had on file, and I shared it with him.
So if I may ask a question, we know that our neighbor to the north, Jason Moffett, did not receive that information. So you're saying that Christopher randomly would ask if we'd submitted anything, because we know the information did not go out to our neighbor to the north. At least he has stated as much. So
Correct. We haven't fully processed it. I was emailing Ryan earlier this afternoon. He indicated that I don't think he's received the revised drawing from Kevin Hansen for your plans yet.
Okay.
So what we have on file is right in front of me on my computer. It's a 17-page application that's date stamped November 30th. And the drawing that you guys had provided was that T-shaped dock that went out farther than your current dock.
Okay.
The F shape that you showed today, it has not been submitted by anybody. So
Okay.
because we're still kind of in that incomplete, waiting for the revised drawing, we haven't mailed anything out to your neighbors, the Moffitts to
Okay.
the north. Once you submit that complete application, we will mail it to the Moffitts, and we also will mail it to the Burkes as part of our standard procedures.
Okay. I imagine what's happening is, I know Kevin was asking questions about the
Right.
forward F dock, because we don't want it to be, rejected again. So we really are trying to comply with the regulations, and it's possible he was having informal conversations, but there hasn't been an official submission yet to IDL. What we do know is our intent is that it's the forward F dock that is being submitted to IDL, whether that's happened officially or not. And that absolutely our intent is not the T-shaped dock.
Okay,
Okay, thank you for clarifying that.
my pleasure.
All right, thank you, Mr. Amer. And again, I just want to thank everybody for the comments provided today. Lots to consider. So to conclude, I'm going to read from the notice of the officer that outlines the next steps for us. It says, the hearing officer shall submit a preliminary order to the director of the Idaho Department of Lands within 30 days after the close of the hearing. After receiving the preliminary order, the director shall issue a final order no more than 45 days after the conclusion of the hearing, or allow the preliminary order to become final 45 days after the conclusion of the hearing. As provided in Idaho Code 67-5240, the contested case provisions of the Administrative Procedure Act do not apply where the legislature has directed the use of alternative procedures. Because the legislature has enacted specific alternative procedures in Idaho Code 58-1305 that require a final order to be issued within 45 days of the hearing and leave insufficient time to consider petitions for review of the preliminary order. The procedures of Idaho Code 67-5245 addressing petitions for review of preliminary orders are not applicable. So with that, I'm going to conclude the hearing. It is now 3:06 p.m. And
May I make a comment, please? I'm sorry, but we actually were not able to hear anything you just said. Is it possible the statement you just read could be emailed out to us afterwards, or?
Yeah, and basically the statement that I just read was directly from the notice of appointment of hearing officer and hearing.
I don't know what's wrong. The other people that spoke, we could understand it, but you're just not coming through.
It's kind of like you're in a tunnel. I'm sorry, but because we really can't hear
We
everybody
just
else.
we can't pick it up.
I'm very sorry, but it's just that if there's something important you're saying right now that affects our rights going forward, can it be emailed to us or something? Because we just couldn't hear it.
I apologize. I'm trying to speak in the microphone. I haven't, that's because I can't. Basically, all I did was read from the notice of the appointment of hearing officer and hearing. So it's already, you already have that in the notice that went out, outlining the next steps.
We're still not getting, we're just,
Sorry.
we can't understand from here. We can't understand you.
Sorry, if I can jump in real quick, Mr. Hearing Officer, I don't think that's the microphone that's picking up your voice. If we can troubleshoot for just a moment, I want to see if we can get this working a little bit better, if that'd be okay.
Thank you.
In the meantime, I think I can actually, I was able to hear Mr. Smith a little bit, and I've done enough of these hearings. I know what's standard for the hearing officers to do at this point. So what I can tell you that Andrew said is the information he just gave about the next steps, you can find that same information in the notice of hearing and notice of appointment of hearing officer,
Okay,
which I think you all have.
yes, we have that. Yes.
So that information has the next steps in terms of the timing for a preliminary order, which will just go to IDWR or IDL, sorry, wrong agency, IDL's director, and then the timing for the final order from the director. And then that order will also then contain next steps that you can
Okay.
take after that.
Okay,
So if you have any questions, if you need another copy of that notice of appointment, let Ms. Romaine, Courtney Romaine, who you sent your exhibits to, let her know.
okay, thank you. We do have that, so.
Okay.
Thank you.
You bet.
Thank you, Ms. Kaufman. Okay, well, with that, it is now 3:09 p.m. And we'll adjourn this hearing. Thank you again for your participation.
Thank
And Chris,
all.
you can go ahead and stop the recording.